Hi, I'm Heather Rahilly, co-chair of the firm's private equity practice group here at Wiggin and Dana, and a member of the M&A practice group as well. I'm here with my colleague, Andrew Ritter, also a partner in the M&A group here at Wiggin and Dana. We'd like to welcome you to our virtual discussion roundtable series for companies and investors navigating the new COVID-19 environment. The last few months have presented a lot of challenges. Many deals are on pause, while PE firms and companies look inward to make sure that their companies navigate this new environment and come out of it successfully. So today we're sitting down with our colleagues in the Labor, Employment, and OSHA practice group here at Wiggin and Dana, Mike Miller and Larry Peikes, and they'll be here to discuss new developments and trends in labor and employment law, new risks and how to mitigate those risks, as well as possible effects on future deals and deal practice. So with that, I'll turn it back to Andrew to ask the first question. Thanks a lot.
Thanks, Heather. So as Heather mentioned, we're here with our partners, Larry Peikes, who is a partner in the Labor and Employment Group practicing out of the Stanford office, and Mike Miller, who's an environmental health and safety lawyer practicing in Connecticut, but serving clients across the country. So we thank both of you guys for being here with us today. The first question is, we know you've both been spending a lot of time talking to companies about how to navigate the current environment. What sort of questions have you been receiving from clients at companies right now with respect to the shutdown, reopening, and how it applies to employees, and what's been your response?
Well, let me start with that, Mike, if I might. There's a lot to unpack here to begin with, but generally what we've seen is questions focused on three primary considerations. How do we open up safely? One. Two, and sort of a subset of that is, when we open up, how do we protect employees who are at high risk? And then thirdly, what do we do with employees who don't want to come back because they have fear or concerns about contracting the virus in the workplace? So let me break those down briefly and cover essentially what we've been talking about with our clients, and keeping in mind it's a very fluid situation, and the guidance that you receive and the insights that you obtain change very rapidly. So let me start with the safety considerations. In a very timely development, just this week, a couple of days ago, the CDC issued very comprehensive guidelines for employers on reopening. It's a 60-page document that covers a whole host of things. But for purposes of keeping this a little bit streamlined, let me cover some of the highlights. So what the guidelines do is they provide interim guidance for certain specific types of employers, companies, childcare programs, schools and day camps, restaurants, bars and restaurants, both bars and restaurants, they cover those together, and mass transit. So areas that you would think they would want to focus on because of the congested nature of those kind of environments. But there's also more broad guidance there as well. So they provide detailed social distancing and safety protocols for employees of every stripe. And they suggest a wide range of precautionary measures that employers can take to minimize the risk of employees getting infected. Some of those include obvious ones, some not so obvious. So the CDC mentions checking ventilation systems to make sure they're operating efficiently and effectively, where you're able to do so, keeping doors and windows open, encouraging teleworking. Obviously, most people who are able to do so have been teleworking for quite some time, but maybe encouraging the continuation of that practice to the extent it's feasible. Certainly, if you have a symptomatic employee, isolating that employee or sending that person home. Same with someone who's come in close contact with a person who's been diagnosed. And the CDC recommends that you be prepared to close your facility if need be, if there is something of an outbreak or one of your employees test positive for the virus. Also, importantly, the EEOC has sanctioned the practice of temperature taking. Usually there are pretty strict guidelines about medical tests and taking temperature as a medical test, but the EEOC, in light of the current circumstances, has somewhat narrowed that restriction and specifically sanctioned the taking of temperatures for employees. I think a lot of employers will be doing that. And it's a good idea. Certainly if someone has a fever, it's probably not a good idea for them to be in the office. So then what do we do with high-risk employees? Well, first let's define them. That's employees who are over 65 and those with certain underlying conditions that make them more susceptible to either contracting the virus or more serious consequences if they do contract the virus. Things like chronic lung disease, asthma, hypertension, heart conditions, if you have a weakened immunity, obesity, and liver and kidney disease. Now, many times you're not going to know whether an employee has one of those conditions and is therefore in a high-risk group. So the CDC suggests that you encourage employees to self-identify if they have one of these conditions. You can't compel them to do so, but encouragement is a good idea, so then you can move into the next phase, which is trying to figure out whether these folks can safely return to work. And one thing you can't do is categorically exclude from someone from the workplace because they have one of these conditions. So you can't say if you have asthma or lung disease that you can't come back to work. It may not be possible, but you can't have a categorical exclusion. So what the guidance is from the EEOC is to conduct what's called a direct threat analysis to determine if an at-risk worker's likelihood of exposure in your particular workplace and whether that risk can be adequately mitigated by reasonable accommodations. So you get into sort of a traditional ADA mode of analysis, looking at accommodations. Some of the more obvious ones we've been doing for quite some time. Continue a teleworking arrangement if that's possible. That's a classic example of a reasonable accommodation under the ADA. Perhaps if that's not possible, can you provide an isolated workspace or segregate the employees from the rest of the workforce so that they're not interacting with folks as readily, and maybe moving people into less congested areas. Some of these things may be doable in one environment, but not another. The EEOC has also provided helpful guidance in the form of a Q&A on medical testing and reasonable accommodation, so I would certainly recommend that to folks to take a look at as these issues arise. So lastly, the third item in my list was, what do you do about employees who are reluctant to return to work because they're fearful of contracting the virus? Generally, I think employers are taking a pretty solicitous and flexible approach with respecting employees' fears and concerns in this regard. In sort of a high-profile moment, the commissioner of Major League Baseball was asked about that, and he said, the players who are not comfortable returning, we're not going to make them return. We're not going to compel them to do so. They may not get paid, but they're not going to be compelled by penalty or something along those lines. And I think that's generally what a lot of employers are doing or plan to do. But there are some employees who are essential to operations and whole jobs that can't be done remotely. The options that you have there, obviously, if it's an at-will employee or someone who doesn't have some contractual right to continued employment, you can terminate the employee for job abandonment. I think that's going to be an option that's used infrequently because I think folks understand that this is a unique situation, and fears and concerns along the lines of what folks are communicating are very real. You can put folks on an unpaid leave of absence. You want to be careful there not to make any guarantees of reinstatement, though. You may need to replace that employee or backfill that position. So you don't want to treat it like a furlough, to use a current term of art, with an expectation of returning. You want to just indicate that you'll place the employee on a leave of absence and consider reinstatement when they're ready to return and see where things stand. And you can also negotiate some sort of compromise solution, circling back to the issue of reasonable accommodations, being creative in that regard. So I think those are essentially the options that are at your disposal. And so those are the three big issues that we've been counseling employers as they begin to make preparations and start to get back to work a little bit.
And I'll pick up on the environmental and health and safety side. Seems like guidance has changed seemingly daily since the stay-at-home orders were issued in March. We've been assisting clients across the country to adjust and modify working conditions, address ongoing environmental health and safety compliance obligations during the pandemic and COVID response. These issues really arise with respect to environmental permitting and regulatory requirements, and OSHA matters, particularly ensuring that there's a health and safe workplace. On the environmental side, EPA and many state agencies met COVID response with publication of enforcement discretion policies. In essence, relaxing routine monitoring and record keeping requirements during the pandemic response time period. And appreciating that even businesses in essential business categories that remained open did so with a limited workforce, while so much of the country was under a teleworking or other order. So difficult for employers to maintain that level of rigor and compliance that they otherwise are expected to. Issues we've dealt with have related to wastewater treatment, plant operator certifications, finding contractors to actually assist at industrial facilities, utility and power generation sector who are under scrutiny and air permitting requirements and record keeping, having difficulty and challenges actually complying with those very strict requirements. But the key to satisfying these policy conditions is adequate documentation about the impact that COVID has worked on the employer's ability to comply. An important note, I think, is environmental groups have challenged EPA's policies, alleging that the policy is an erosion or a rescission of important environmental protections. And I guess from my stance, to be clear, the policy, it doesn't immunize employers or the regulated industry from addressing or complying with requirements relating directly to human health and the environment. It also doesn't give employers a free pass to not deal with compliance obligations related to spills and releases. Really, the focus of these policies are routine monitoring, record keeping, et cetera. On the health and safety side, with respect to OSHA, there's been much more activity, as you can appreciate. There's a real fear and trepidation in some sectors about employees returning to work for those who weren't in the essential industry categories. So going back to March 2020, OSHA published some very lengthy guidance about how workplaces should be addressing COVID response issues, categorizing work tasks by way of exposure. So high exposure being those in the healthcare industry or first responders, the medium exposure being those who interface with the general public more, like a high volume retail store, and then lower exposure being like a manufacturing setting or service setting where you have very limited exposure to others, ensuring that there's social distancing, of course. So again, OSHA has been much more active in our experience than the environmental regulators, largely in responding to, as is their charge under statute, to employee complaints about unsafe work conditions. We've assisted employers across the country responding to these complaints, and I think the most critical component to a strong response, and one that has a better likelihood of closing out an OSHA investigation, is to demonstrate that the company has a robust, thoughtful, and deliberate program in terms of addressing the COVID response actions and complying with OSHA's expectations in the March 2020 guidance. Unfortunately, we've also been on the side where there are some employees who, no matter what level of rigor or compliance protocol has been established, there are employees who just don't want to return to work. And there have been repeated employee complaints, unsupported ones. And even those types of complaints, they lead to business disruption. And the employer is left dealing with the agency and being, a focus of the agency's attention, which is never a good thing. I would say some agencies in the state plan states have been more active than the federal government and the regional offices. For example, Oregon OSHA, perhaps just by way of the sheer numbers of employee complaints they've received, which last count totaled over 3,500. That agency has issued enforcement citations for failure to comply with distancing practices, et cetera. We just haven't seen that type of activity across the federal OSHA region offices. Instead, it seems the approach approach is to focus on the healthcare and first responder industries, those high risk areas, and then deal with the others by way of employee complaints and responses. One last issue that's been kind of front and center for employers is how do you deal with injury and illness reporting and recording obligations. Just as a general rule of thumb, if there's an injury or illness that's attributable to a workplace exposure, the employer has an obligation to record the incident. And then if it's a serious injury or illness resulting in hospitalization or a fatality, there's an obligation to report those incidents to OSHA. And OSHA came out with actually vacillating guidance on, from one end, saying that they're going to excuse industries largely from making that threshold workplace determination during the COVID pandemic, other than in the healthcare setting. To just recently this week, they're kind of rescinding that guidance and going back and requiring industries to make the threshold workplace determination. So it remains to be seen how OSHA will take companies who relied on the earlier April guidance and failed to do that type of documented workplace work-relatedness determination.
Great, thanks, Larry. Thanks, Mike. I that's all great information. I think, I've heard from GCs at many companies, during the lockdown who had businesses designated as essential businesses, and now more with, PE funds that have companies that are non-essential businesses but reopening, that they're, very concerned about, doing the right thing to avoid mitigation, to avoid litigation risk by, customers, employees for being exposed to the virus. And I understand that it's hard for these agencies to make bright line tests, but it seems like a lot to navigate for companies. How do you make the right call with respect to a large employee force with a lot of factors and still try to achieve, as close to business as usual, because, we have to operate and go on. So my question is it a real risk? Is there going to be increased suits because of this reopening and the lack of bright line tests? And if so, what can these companies do to put their best foot forward and mitigate that risk?
That out again, from an enforcement perspective, I know the questions about litigation, which I'll get into, but from an enforcement perspective, we just haven't seen a watershed of enforcement activity by way of citation or assessment of penalties. It does seem that the agencies are working with employers. We've all heard about the meatpacking industry being cited as the most kind of recent hotbed of COVID. 20 state attorneys general sending letters to the federal government demanding stricter standards. So anytime there's a perceived or requested regulatory change, it seems it's a setup for litigation. But there is at least precedent as of recent that those types of lawsuits either will be dismissed, like a recent federal judge dismissed a case in Missouri alleging unsafe work conditions at a meatpacking plant, and the judge cited that OSHA has jurisdiction over the issues. And I'm sure Larry can talk about, we're seeing a lot of unsafe workplace lawsuits arising in the docket reports that we get on a general basis, but these might actually end up being more workers' comp cases. Larry, do you want to take that?
Yeah, and that's sort of I hate to use the term, but good news in this context is that generally speaking, claims for work-related injuries and illnesses are covered by workers' compensation insurance. So those kind of claims are litigated in a workers' compensation forum to the exclusion of any tort claims against the employer. And of course, every employer is required to have workers' compensation insurance. So those kind of cases tend to be resolved in that forum with the insurance company running the show, as opposed to the employer having to deal directly with the litigation. I think the key issue in those cases is going to be causation, because I think it will be very difficult for an employee to show that she contracted the virus at work. I think identifying the source of the virus in any individual cases is a difficult task for the most qualified folks in the world to do. I think that's going to be a significant impediment to workers' comp recoveries, but again, that's all insurance related. There is a carve out in pretty much all states from the exclusive remedy provisions of the workers' compensation laws for cases where the illness or injury can be attributed to gross negligence or deliberate conduct on the part of the employer, which sort of brings us back to the mitigation protocols that I was talking about a little bit earlier to make sure your workplace is safe to reopen. This is just sort of a litigation-related reason for that, separate and apart from obviously maintaining an environment where folks can be confident that they're going to stay healthy. There's also that litigation risk, albeit somewhat remote, that someone who does get sick or in your work environment because of obviously inadequate safety protocols could bring a tort claim outside the scope of workers' comp on that basis. I think, and as Mike alluded to, we've also seen lawsuits initiated by employees who have not become ill, but have accused the employer essentially of not having adequate protocols in place, and that gives rise to a fear on their part that they will become sick. These could be claims for something like negligent infliction of emotional distress or some sort of tort claim, which is outside workers' comp because the employee isn't actually ill, but has anxiety or other emotional responses to the fear of getting ill. And we see some of those cases getting filed as well. Obviously, way too early to see how they turn out. I think the employees will have a difficult burden of proof there to meet, but that could be very sensitive litigation that employers would be wise to take steps to avoid as best they're able by, again, implementing these safety mechanisms and protocols, especially as suggested by the CDC and state and local authorities.
Right. So I think what I'm hearing is that while, both on the injury and the termination side, there likely is an increased risk just given all the factors we have, that there is some, deference to having these cases, relegated to the agencies and under current, insurance schemes, and that if companies are proactive, acting reasonably, and putting policies in place to prevent these problems from happening, that they can, somewhat rest easy that they're doing the right thing and that they're not going to be at increased risk for being dragged into these types of situations and proceedings, right?
Yeah, I think that's right. I mean, we know for certain there's no perfect solution here. There's no employer that's going to be able to set up an environment that is COVID-free and will remain COVID-free. That's just not, unfortunately, possible. So it's a matter of doing the best you can. And part of that, I think, is educating yourself, and why we would certainly encourage folks to actually look at that CDC guidance. It's 60 pages, it's comprehensive, and follow those guidelines to the extent they apply to your particular workplace. And again, to also follow local, state and local recommendations as well, which are published. So there is a significant element of educating yourself that will be a litigation avoidance mechanism, a risk reduction mechanism, and most importantly, will be the best way to keep your employees safe when they come back to work.
And I would just add on the risk reduction piece, we're aware that in New York, there's a requirement if you have employees in close contact for more than 10 minutes, that you're required to keep a log of that interaction, which could essentially be an admission that social distancing or distancing practices are not being upheld. So I think to Larry's point, although you have all these different layers of federal government oversight and local government orders, just be mindful of the types of records that are being generated and making sure that you're not leaving things unresponded to, because that would be a great way to reduce your risk in the event that there is litigation.
Yeah, I mean, just to follow up on that point also, I mentioned earlier the idea of taking employees' temperatures when they come back to work. You're going to want to log that. And obviously, those are the kind of records you want to maintain in confidence. But those can come back to hurt you as well if you're just doing it and not doing anything with the information. So if those logs reflect you of people who are running a fever and you don't send them home, that's not going to be a good piece of evidence. So it's not a matter of going through the motions and doing it. It's extrapolating from that information what protective measures we need to put in place on a case-by-case basis.
Right. Yeah, that's all helpful information. I think that might lead us to our next. I think that's going to be a big job for companies, and that type of record keeping is going to come up when we do get back into deals and companies sell themselves and buyers are, looking behind the curtains. I think we're going to have a whole new area, right, Andrew, for buyers to diligence and look at in deals now, because companies are going to have these new restrictions that didn't exist before.
Yeah, I mean, this is definitely going to be, I would think, a decent chunk of the diligence bandwidth, at least for the near term. And I think you've talked about thinking of it from a litigation standpoint, from a defense standpoint, taking records of violations of social distancing or taking records of temperature checks. Do you have recommendations of how people should be preparing if they're looking, on a go-forward basis next year to run through a sale process, how they should be thinking now to be prepared for COVID-related diligence, in the near future? And then I think on the flip side, if you're a buyer, what are you recommending people really think about from a due diligence standpoint, and what are you recommending that they ask for? What sort of records do you think people are going to want to see?
Yeah, I think, just in general course, on the environmental health and safety side, we always look at operational risk, permitting and regulatory requirement, compliance. I think we're going to be viewing those components and those issues with a different lens now, particularly during this time. A couple of things come to mind. Is the company claiming, coverage under one of these enforcement discretion policies where they have a gap in compliance that wasn't addressed? And if they are, is there a good faith showing and documented demonstration that they actually satisfy the conditions of the policy? Get out of jail free card, as you will, from the agency, but documentation will be key. A couple of other things that we might end up throwing in our diligence questionnaire for target companies would be, do you have an infectious disease preparedness plan? Do you have employee complaints during, COVID-19 response actions? Were they addressed, and what were your responses to those? Any citations related to COVID? Workers' compensation claims? Any coverage issues with your carrier on that front? And then I think just from a kind of a deal perspective, right, taking a step back from diligence that I'm typically involved in, was how did the business target kind of fare during this time? Was it susceptible to business closures and uncertainty? Was it an essential business? Are the suppliers upon which its product relies susceptible to business closures? Just looking at the past performance. And then I guess I think lastly, contractual diligence, collecting the company's contracts, and probably going to be expanding the view of contract diligence, just to look at it from a different perspective. Do you have any way to get out of these obligations in the event of a pandemic? Any wiggle room in those types of provisions, those force majeure and other clauses that some of us haven't paid attention to until now.
Yeah, and those are all excellent points, Mike. I had some of the same thoughts, and just in terms of the employee relations perspective in particular, I think there are some privacy considerations that may come into play here that perhaps in a typical deal historically you wouldn't have to be too concerned about. So, for example, I mentioned the idea of taking employee temperatures and maintaining a log. Is that something that would be subject to being reviewed in a due diligence context, given the ADA requirements for maintaining confidentiality of medical records? We haven't talked about it on our program today, but way back at the beginning, in late March, Congress passed some very significant legislation in terms of paid sick leave and amended the Family Medical Leave Act to include some paid provisions. Will that be part of the due diligence inquiry, just to see, one, whether the company is complying with those obligations, but two, in that context, would that disclose employees who were ill and maybe provide some medical information that otherwise would be protected as confidential? That might be important stuff for an acquiring company to know. Has the target been compliant with these paid sick leave obligations, which are not the easiest thing in the world to figure out and apply? And also, and I think this is subsumed within what Mike had said about regulatory compliance. I know in many deals that involve entities that are not manufacturing or healthcare, or more office white collar environments, nobody's really focused too much on OSHA compliance and OSHA complaints that employees may have registered. But now those sort of complaints can be brought in any type of environment. And maybe it's something that in the past in the due diligence process, you just sort of skate by or not even focus on whether there have been any OSHA type complaints. I think we're in a different world now. That might be something to focus on as well, because there may be OSHA claims or OSHA complaints or safety related complaints or workers' comp type claims in an environment where you historically wouldn't see them at all.
Right. Yeah, I think that there's going to definitely be, new reps introduced in purchase agreements that buyers are going to ask for that we've never seen before. I think people who may have in the past breezed over, HIPAA compliance reps and OSHA events disclosed in schedules that were usually seemed pretty mundane and ordinary course, there will be renewed focus. And then I think sellers are also going to be, have to grapple with, what level of certainty they have in giving those new reps. It'll be interesting to see. It'll, also be interesting to see if, the insurance industry, who there's an environmental insurance for deals out there, will new products be introduced to maybe cover some of these concerns to get, buyers and sellers more together on these issues.
Yeah, I think that's a great point. Actually, I've been talking to insurers recently for whatever reason. I think my impression is that they had really ramped up and were ready to have a big 2020 from insurance reps, reps and warranties insurance side. And obviously the demand hasn't been there. And from the conversations I've had, they are definitely focused on being creative and figuring out a way to provide value in deals and fashions that they might not have in the past. And I think it'll be interesting to see just how much they do and what sort of kind of bespoke value, they're able to provide given, the incentives that they're faced with. And the risk allocation point's good too. I mean, I think a lot of people on the deal side are focused on some of the more obvious issues that they're going to have to grapple with, which is how do you address value and, divergent opinions and value and how you factor in, COVID slumps. But the risk allocation piece is going to be there too, and it's going to be nuanced, and people are going to have to grapple with that on a company by company, industry by industry basis, and it's going to be, it'll be interesting to work through. But Mike, Larry, appreciate both of you guys being on today and talking with us. I thought it was very interesting, and hopefully, people that do the program think it was interesting as well. We'll be coming back in the next few weeks with sessions with some of the other partners at Wiggin on the export control, CFIUS, tax, and other sides, and hopefully people tune in for those as well. So thanks
everybody.
Thank you.